Trustee Velasquez.
Before the court for the purpose of reviewing defendant father's parenting time, this hearing is being conducted via Zoom. Plaintiff Emily Connors is present, and attorney Scott Musson, representing the defendant, is also present. Is Jesse Velasquez present?
My volume's all the way up. I don't know if it's my end or.
Yeah, we can. Can you hear the court?
Yes.
All right, good. Good morning. Good morning, Mr. Musson. All right, the parties have conferred this morning with the friend of the court. The court has received the following recommendation that father shall have parenting time every Friday from 12 p.m. to 5 p.m. The father will not have parenting time until the outstanding bench warrant has been addressed and recalled. That is the recommendation. And Mr. Musson, is your client to agree with this recommendation?
Yes, Your Honor, he is.
Ms. Connors, do you understand the recommendation?
Yes.
Okay. Do you have any objection to the court adopting the recommendation, Ms. Connors?
Where are we meeting?
Was that discussed?
No.
No.
Okay.
No.
Okay, then that's a very good, legitimate question, should be addressed. Now, let me ask first, Mr. Velasquez, what needs to be done in order for your client to address this bench warrant? Is this something that was issued by this court, requested the front of the court? Or is it a criminal bench warrant?
Your Honor, my representation has ended, so I was not aware of the bench warrant. It's my understanding that there was a failure to pay the support. A show cause was issued that was not appeared for, and a bench warrant issued as a result of that. I'm also told if he pays the $1,000, he's able to clear it, which my guess would be that's the back support that's owed.
All right, so it's a warrant issued by this court, not a criminal warrant. Does your client have a valid driver's license, Mr. Musson?
I would have to to find out.
I do not currently. I just have a state ID.
All right, Mr. Velasquez, I don't know why your license is not valid, Mr. Velasquez, but if you take care of the bench warrant, I don't know if that resulted in the suspension of your driver's license, but you want to get that straightened out, especially if you're going to transport the children. So the only way this is going to work this parenting time is if mom does all the pickups and drop-offs. Ms. Connors,
I would have to discuss. I would make sure with my wife that she could do this for me because she's been the one currently helping me get back and forth from Flat Rock to Monroe for the supervised visits.
Okay. Mr. Musson indicated that apparently the friend of the court attorney wants you to pay $1,000 toward your support of urges to lift the bench warrant. Can you do that?
Currently, I have no ability to do so. I've been going to work. I have moved out into the boonies because the one place I was lined up to get fell through. So I had to move to my dad's house, which is Flat Rock out in the middle of nowhere. It's literally like a 5-mile walk to town. Yes. I'm trying to get more hours as well. So that way I can start getting back on track with everything.
Well, the court's reluctant to deny parenting time based upon the outstanding bench warrant as long as Mr. Velasquez is not transporting this child.
Like I have no car. Like I've been using, if the only way to get around is my wife's car, and that with her, she has to work constantly.
Okay. Well, again,
I made sure, like for things like this, I make sure I have a ride. Okay. That's why I walk to work.
Presumably, parent time would be in your home. Are you off on Friday afternoons?
Yes. Currently, Fridays, Saturdays, and Sundays.
Okay. So is your wife? Can she pick up the child at noon on Fridays and drop off the child back to mom's house at 5 o'clock?
Could we?
I don't want them coming to my house.
I was going to
suggest. Let's meet at the some middle point location. I'm not sure which of you resides. We can meet at the sheriff's office, a police station.
We can meet at the same place that we drop him off for the meetings.
Okay. Was that Family Counseling Shelter Services?
Yes.
Okay. Will that work, Mr. Velasquez?
Yes, if we could do it there.
Okay. And your girlfriend's available, correct, at noon and 5 to transport the child?
My wife, or if anything, I would consult with my mother to see if she can pick up and drop off with me.
Well, it's got to be, Mrs. Connor should know who's picking up, who's dropping off, and your 3-year-old child should know who that person is. Does your 3-year-old child know your wife, know your mother?
2-year-old child?
Oh, I thought the child was 3.
No, he's only 2.
All right, I'm going to talk with Mr. Pratt briefly, and maybe you can agree upon. Mr. Pratt, the court's not going to deny parenting time. I'll take bench warrant. Obviously, as long as Mr. Velasquez is not operating the motor vehicle because he doesn't have a valid license, Mr. Velasquez, the worst thing you could do to your child is be arrested in your child's presence. So even if you're accompanying your wife in the car and she gets stopped for speeding and they check your ID, it's going to be it's not going to be real pleasant for you to be taken away and arrested in handcuffs in front of your child.
No, it would not. But I'm trying to get all my ducks in a row, Your Honor. I'm doing what I can with what I got.
All right. Well, as long as you're working on that, and yeah, even if you got to borrow money from your mother, get your life straightened out, because you don't want to be stopped on your way to work if you got someone driving you, and then having to take the jail because you spend time in jail. Mr. Velasquez, take care of it. It's been outstanding since May. It looks like it's an $800 cash bond. So keep in contact with Miss Hicks from the front of the court attorney. So we're going to talk with Mr. Pratt regarding the pickup and drop-offs and where and who's going to transport. But the court will not require that, will not hold off that parenting time, even though there's an outstanding bench warrant. Mr. Pratt, do you have a few more minutes to talk with the parties regarding the pickup and drop-offs?
I do, Your Honor.
Thank you. Okay, we're going to put you back in the breakout room. And Mr. Musson, after today, you're going to be done representing Mr. Velasquez. Is that correct?
Yes, Your Honor. I've actually moved on and doing a no-fault PIP defense. So I haven't done family law in a while. And I meant to tell you that at the last hearing. I'll get a withdrawal form in for you, so you know I'm not the attorney of record.
Okay, and make sure Mr. Velasquez also is aware of your intention in that regard.
Yes, I will.
Okay, all right, put you back in the breakout room.
Thank you, Your Honor.
Okay.
Welcome.
Thank you.
Andrea, I see that on the caucus matter set for pre-trial the same day. That's probably why Anemic did not reach out to you, because she just tagged on the motion to the pre-trial. Yeah. So I was trying to think, why would she reach out to you and let you know it's vacated? Because they're going to be here anyways on a pre-trial. Right. Okay, I didn't realize that. Nancy was just telling me that. I thought.
But that's why I said if they're usually working with Nancy, they'll usually just work through her.
But we already had that set. I think they tagged it on.
Yeah.
Because Nancy was not aware that the motion had been vacated.
Oh, really?
Yeah, it was just in the order. Yeah.
Good morning. Are you Eric?
But the reason they did reach out is because it was already pre-trial set anyways.
Right.
So you got to appear anyways. Has received a revised recommendation from Ms. Pratt this morning. Again, that the parties shall meet at Family Council Shelter Services to do the exchange of the minor child for defendant father's parenting time, which will be on Fridays from 12 noon to 5 p.m. The parties shall communicate using app close. So, Mr. Velasquez, who's going to be doing the driving? Your wife or your mother or your sister?
It should be my wife or my mother as a backup.
Okay, and does the child know your wife and your mother?
He used to. She was bringing him around them quite often.
Okay. Do you have a car seat?
Yes, I do.
All right. Ms. Connors, do you understand the revised recommendation? And
Yes.
do you have any objection to the court adopting this as an order of the court?
No.
Okay. Obviously, you want to make sure that there's a car seat in the car picking up. And again, it'd be a courtesy, Mr. Velasquez, if you simply inform Ms. Connors. It's a simple courtesy to let her know who's going to be picking up, who's going to be at the exchanges, whether it's your mother or your wife. That's the right thing to do. Okay. So that presumably will start this Friday. Is that correct?
We already had our meeting Monday.
Okay. I'm not sure what meeting you're referring to.
They had supervised at the center, Your Honor, on Monday night.
I understand. All right. So this will start then a week from Friday?
So not this Friday, but the following Friday.
Correct.
Okay.
Is that agreeable then, Ms. Connors and Mr. Velasquez?
That's
Yes.
agreeable.
All right, just want to make sure I'm both on the same page, right? That this training time will begin a week from Friday, which is November 22nd, 12 to 5. Okay, if there's nothing further, the court will adopt the recommendation, and that will conclude this hearing. You can both zoom out.
Okay, thank you.
Thank you, Ms. Brad.
Thank you, Your Honor.
For the record, this matter is before the court for the purpose of reviewing parenting time. Primarily, I believe the defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing the plaintiff mother, Kendall Toll. Ms. Toll is present. In addition, defendant father Eric Sims is also present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred with Ms. Brower this morning for the front of the court, who has provided the court with fine recommendation. It's noted that both parties have completed their intakes at family counseling. The defendant father needs to contact Ethan at Family Counseling Child Services to schedule the sessions. That the parties appear back for its court to review parenting time on Tuesday, February 4th, 2025 at 8:30 a.m. via Zoom. That is a recommendation. Of course, the court wants to keep this matter on its docket until we can reestablish this relationship between the dad and his 13-year-old child. Ms. Zagorski, is this recommendation agreeable with your client this morning?
It is. Thank you, Judge.
All right. Mr. Sims, do you understand the recommendation this morning?
I do.
Okay. Do you have any objection to the court adopting this recommendation?
Could we modify it?
Go ahead. Did you discuss that with Ms. Zagorski this morning and Ms. Toll?
No, I just want to have every order that I looked through them this morning. It states that I am to do the therapeutic visitation at Family Counseling Shelter Services. Could you modify it to state that I could do it there or somewhere else privately? Because this has just been drawn out for so long. The longer time goes on, the more it hurts my heart that I'm not seeing my kid. And every time I come to court, I ask if I can FaceTime or text my child. And every time I get told no, and then months go on and I still haven't seen her talk to my kid, and it hurts.
The court can appreciate that. The court had a question because Caleb is still involved in counseling. Is that correct?
Kendall,
Caleb could not get in either.
is he on the wait list of family counseling?
He is, yes.
Well, there should be a different agency. The court, in terms of FaceTime, the court made a note that the court was looking for a recommendation from Caleb's counselor, and he's not in counseling right now.
No, Judge, my client paid out of pocket for a very long time. And the whole time that Mr. Sims was incarcerated, my client was paying out of pocket, and then that ended, and the court did order the child to be re-enrolled in counseling, and she's been on a wait list at family counseling.
Okay, so the Caleb has no insurance?
Yes, he does. Yes, he does, but I still had to pay.
Okay, well, what's the out of pocket? Let's get a different agency. I mean, the court ordered that some time ago. I was not aware that Caleb was no longer in counseling. This court will not permit a 3-month or whatever wait list. So we need to find a different agency. If they don't have time to see Caleb, then we need to get a different agency. There's a number of agencies. Ms. Gorski, you're probably familiar with them. You can give Ms. Toll some direction on some agencies.
Sure.
We need to establish a relationship between dad and the child. It's going on way too long. The court would agree.
Your Honor, I appreciate that, and I would note that Kendall has been contacting Family Counseling and Shelter Services over and over and over again.
Okay. But let's find a different agency. If they're understaffed, overworked, understaffed, let's find a different agency, Ms. Gorski. There's a number of them.
Judge, you've already ordered that Mr. Sims could arrange for a private therapeutic visitation. You ordered that. My client's willing to do that. Mr. Sims has never taken any action to obtain that. And today he provided an email from Family Counseling and Shelter Services that stated he went 3 months without contacting them at all. So I just want
counseling for the child.
I'm sorry?
Hold on. I thought we were talking about counseling for the child Caleb.
I'm
Caleb is
talking
not
about
involved in
both of
counseling.
them. Both of them. For
Well, there are
Caleb and
two different things, Mr. Gorski. One is
Yes.
the therapeutic parenting time, and one is the child being involved in counseling. And the court last time said the court would put in FaceTime. The court wanted a rec from the counselor. So when we were last court on September 17th, the court was never informed of the child still on waitlist. He's not seeing a counselor. And I was hoping that we have some recommendation from that counselor today about having FaceTime with dad.
Understood.
So let's talk. I'm going to put you back, Ms. Brower. Talk about it. I want to identify another agency. The child has insurance now, correct? What's out of pockets? Maybe Mr. Simpson paid the out of pockets. That's it. We can't wait. So we're going to figure about family counseling and child services in terms of Caleb's parenting, Caleb's counseling. That is a priority.
Okay.
So if cancel the family counseling child services, that's way too long. Ms. Gorski, what other agency would you suggest?
For therapeutic visitation, I think it's going to have to
talk about Caleb's counseling, the minor child's counselor. If the family counseling child services does not have, they're understaffed, overworked, let's find a different agency for Caleb.
I'm going to ask.
Issues.
I'll have to ask my client what insurance she has, and I'll go online and I'll try to find somebody this morning, Judge.
Okay, I'm going to put this over for a week. I want Ms. Toll to enroll this child in counseling this week. Does Mr. Sims, do you have insurance covering your son? Your son?
No, I only have insurance covering myself.
Okay. Well, why isn't your son put on there?
From my understanding, years ago when we were in court, I was told that he was covered by Kendall's husband's insurance.
Well, but he can be covered by two. Is it something you can't afford? Both of you should carry insurance on this child. That's going to minimize the out-of-pocket expenses.
Yeah, I mean, I could check in to get him added to my insurance. I have state insurance myself.
Okay. Well, I'm going to put this over for 1 week, and I want you to put this child on your insurance. And I want Ms. Toll to come back with the name of an agency that she's contacted as an appointment scheduled for Caleb. Now, the other issue is family counseling services. Apparently, they do not have the availability of therapeutic parenting time, licensed therapists. Ms. Gorski, is your client opposed to supervised parenting time?
Yes.
All right. Well, the court may order next week if that agency cannot provide a date. Ms. Patrick, you just zoomed in. Perhaps you can contact the agency. How long are they without licensed therapists?
Your Honor, I spoke with family counseling this morning. They do not have a wait list on therapeutic visitation. Ethan was hired about a month ago. They need to reach out to Ethan as he handles his own scheduling.
All right. So, Mr. Sims, you call Ethan today. Do you understand that? Schedule that first therapeutic counseling session.
So, Your Honor, I was on the phone with family counseling shelter services for about 20 minutes while I was on hold with a friend of the court this morning. And they stated that both the therapists at family counseling shelter services have been approved by their director and the director of the friend of the court to do therapeutic visitation, but that neither one of them's licensed.
Well, apparently Ethan is new, and he's apparently licensed to do this.
Well, we were talking
call Ethan today.
We were talking about him in particular, and he's actually not licensed. He's in school to become licensed.
Your Honor.
I just wanted to bring it up because I don't want it to become the next roadblock and issue and draw this out even further.
Right. Ms. Brower, you spoke with Ethan or someone from the agency this morning?
I did speak with someone from the agency this morning, yes. Ethan handles his own scheduling for therapeutic visitation.
Okay, so he must be licensed then if he's handling therapeutic anytime. The court can assume that. Ms. Patrick, do you have any information?
Yes, Your Honor. There's master level social workers there. Sometimes they have candidates that are working on their master's degree and are about to finish that also work there. They work under a master level social worker. We've had this discussion before, and I have approved it when the backlog got too bad because I am aware that the court likes to move these cases. So I have approved those candidates to work on these cases to keep the cases moving. They work under a master level social worker, and they're working on their master level social worker degree.
All right, thank you. So, Mr. Sims, you called that agency today and asked for Ethan. Schedule that first session.
Okay.
And they'll reach out to Ms. Toll. So hopefully we'd have this done. So I'm gonna put it for 2 weeks so that we have a session scheduled in the interim. And then the court wants Ms. Toll to come back with the name of a counselor and when that first session is scheduled for Caleb. And one of the issues that the court like from the counselor is whether or not FaceTime is appropriate. Maybe we wait till after there's been some face-to-face contact between Mr. Sims and his son. And the court was also, Mr. Sims, you ordered to place Caleb on your insurance. So we're going to review those issues.
So you're
back in 2 weeks.
In order to
Ms. Skorsky available on the 26th of November, 8:30 or 10:30. That's a Tuesday morning.
I have a mediation with Mr. Godfrey starting at 9, so if I could have the 8:30, I would appreciate it.
Okay, 8:30. And Ms. Rao, we can revise recommendation, record review these matters at November 26th. That's a Tuesday at 8:30 a.m. via Zoom. So, Mr. Sims, call Ethan today, contact your insurance, and get Caleb added to your insurance so that we can minimize any out-of-pocket expenses.
So in order to add him to my insurance, I'm gonna need Ms. Toll to forward me Caleb's social security number.
Okay, Ms. Sikorsky, can you secure that and provide that to Mr. Sims?
I think I have it. I'll figure it out, Judge.
Okay, so Ms. Sikorsky will provide that to you, Mr. Sims. And do you want it emailed to you, or how is that going to be handled over the phone? Can Ms. Toll provide that, or is there no contact between the parents?
No, there's not a no contact order.
Yes, there is.
So even the phone calls are not permitted, is that correct?
There's no contact order, Your Honor.
So Ms. Sikorsky, do you have Mr. Sims' phone number? You want to call me? I hate to put the social security numbers in a written email form.
I do not have Mr. Sims' number.
Okay, Ms. Brown, does your office have this child's social security number by any chance? Probably not.
We do. Our office does not provide that to the parties of the cases, though.
All right. Okay, Mr. Sims, why don't you provide Ms. Sikorsky with your phone number? She will call you and provide you with Caleb's social security number.
You want me to
Mr.
do
Sims,
that?
your phone number, please.
734.
All right, Ms. Sikorsky will provide you with that. Anything further than this morning, Ms. Sikorsky?
No, thank you, Judge.
Okay, if any, Carl would appreciate your assistance in directing Ms. Toll to another agency so she can make those contacts today to schedule the first counseling session for Caleb. Anything further, Mr. Sims?
No.
Okay,
No.
Call Ethan today. Call Ethan this morning, get that scheduled, and we'll review this matter November 26th at 8:30.
Sounds good.
That will conclude this hearing. You can all zoom out. Have a good rest of the morning.
Thank you.
Thank you, Your Honor.
Okay.
Toll versus Eric Sims.
For the record, this matter is before the court on plaintiff's motion to modify child support as well as review defendant father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing the plaintiff mother, Kendall and Toll. Ms. Toll is present, and defendant father Eric Sims is also present. Good morning, everyone.
Good morning.
Parties have conferred a length with Mr. Walker from the front of the court this morning, who has provided the court with fine recommendation that the minor child, Caleb, and father shall start family counseling with Yvonne Strand at YLS Counseling Services or with Signe Newcomb with Lemon Tree Counseling Services. The minor child shall continue weekly individual counseling sessions with Kelly Mystery. Father shall pay for any co-pays or other out-of-pocket medical expenses for the family counseling. Mother will provide a copy of the child's insurance card to father in order for father to add the minor child to his insurance. And the issue of child support shall be referred to the front of the court for formal investigation recommendation, with each party having 21 days in which to object to any recommendation, in which case it'll come back before this court. And each child support modification shall be effective December 1st, 2024. Finally, the parties will appear back before this court to review these issues on February 25, 2025 at 9 a.m. via Zoom. That is a recommendation. Ms. Gorski, is this recommendation good with your client this morning?
It is.
What's the situation with Family Counseling Child Services? Are there too backlogged for Mr. Sims to get into that agency?
Apparently, Judge, they don't offer therapeutic counseling at this time. Who knew? I learned that this morning. The last time we were before Your Honor, we understood that there was a gentleman named Ethan or Evan that was available to do it, and learned this morning that that is not in fact true.
That's unfortunate, frustrating for this court. In any event, Mr. Sims, do you understand the recommendation this morning?
Yep.
It's very unfortunate that this agency does not have the personnel to assist the court with providing therapeutic parenting time. The court wants nothing more than to reunify and reestablish that relationship between you and your son. So, are you agreeable with this recommendation this morning?
Yeah, I have an appointment scheduled with Sydney Newcomb at 2 p.m. on Friday. So
good. So that'll be just initial, just a session between you and Miss Newcomb, and then you'll talk, and then you'll schedule something with you and Caleb.
My understanding that session would be with me and Caleb.
Okay. Mrs. Gorski, is Miss Tola aware of that scheduled appointment on Friday?
Well, Mr. Sims said he had an appointment this Friday at 2, but I don't know how a therapist could begin without having first done an intake with the parents about what the issues are. So I know, to answer your question, no, my client did not know that Caleb was to be available on Friday at 2. She was not aware of that.
Mr. Sims, have you met with Miss Newcomb yet? Does this be the first meeting?
I have not. So me and her were talking about this situation yesterday because I'd spent the last week and some change calling different places, most of which do not provide family counseling and or therapeutic, which is why I asked that the order be changed, because if it stated family counseling, our insurance would cover it versus anybody having to pay out of pocket. Sydney was one of the only ones that I had come across initially in Monroe County that was able to do family counseling and or therapeutic. I would have to double check with her. I just was under the general assumption that it would be 2 p.m. Friday with her and Caleb, but I mean, it does make more sense that it would just be with me solely. So,
because the court would think so, if that's what your initial conference with her, she's going to get just information, background information about how old your son is, how many children are there, so forth. What are the issues? What prompted this issue, strain of relationship between dad and son? So I assume that obviously Miss Toll is not aware of that, so Caleb will not be present. It'll be just with you, and then you'll need to provide information for Miss Toll, so Miss Toll can contact her. And Miss Toll, when maybe Mr. Sims can, I don't know how you're communicating right now. Is it through app close, or can you communicate and provide that information to Miss Toll in terms of Miss Newcomb's phone number? So Miss Toll perhaps can conduct an intake over the phone. Then you can get scheduled that first session with Caleb. But the court would assume that's the way it's going to work, Mr. Sims.
Yeah.
Okay, so obviously we've already chosen at least an initial counselor. So you need to communicate. Can you communicate with Miss Toll in terms of having her contact Miss Newcomb?
Yeah, I believe us.
Right. Maybe perhaps Mr. Gorski, Mr. Toll can contact Miss Newcomb today or tomorrow in advance of that meeting, and provide information to Miss Newcomb so we can move on things.
Sure, you can do that.
Can you get a phone number for Lemon Tree Counseling Services for Miss Toll?
Yeah, I could probably find it online right now.
Yeah, perhaps you can assist her with that, and then prior to Ms. Toll, the court would request that you call him, if not today, and say that Mr. Sims has a conference with you on Friday at 2:00, and it's trying to reunify the relationship between Mr. Sims and his son Caleb. Perhaps you can tell you whether or not the intake can be done over the phone and whether you need to meet with her in person. So why don't you make that contact today or tomorrow so we can move on this?
Kendallin, you want the number?
Yes, please.
I got her direct number.
Okay, go ahead, Mr. Sims.
734-770.
Okay, good. So we can move forward on this matter. All right, so Mr. Sims, do you have any objection to the court adopting this recommendation this morning?
No.
Okay, and Ms. Toll, you get, I don't know, you make a copy and text that insurance card to Mr. Sims. How are you going to get that information to him?
She can send it to me, Judge, and I have Mr. Sims' email address. I can forward it to him.
Okay, so hopefully we can do that this week yet. I know it's a short week, but let's get that done so Mr. Sims can take that information in when he meets on Friday. So if we can get that done. All right, anything else this morning, Ms. Zagorski?
I don't know if you saw it. Mr. Sims was provided a copy and the front of the court has a copy. The child's therapist did do a letter to the court dated November 20 regarding Caleb. I don't know if you have seen that or if you want to review it, but it is available for you. You had ordered that the child return to counseling and he has done so. And he went back to his old counselor and she did write a letter.
I did not.
I think I provided it to the front of the court. I didn't want to have direct communication with Your Honor, of course. So I sent it to the front of the court and I think it's in the private or, the non-public portion of their file. Just wanted you to know it's there.
Okay. All right, so counseling will continue then for Caleb. Anything further then this morning, Mrs. Zagorski?
No. Thank you, Judge.
Mr. Sims. Mr. Sims, any questions, concerns?
Could we add one thing onto the order?
Go ahead. Hopefully discuss that with Mr. Walker.
No, I mean, it's just something I was thinking about just sitting here because our next review date's not till February 25th.
Okay.
My son's really involved with sports. I would like to be forward as his sporting schedules.
We'll wait and see how the counseling goes and how things work out. I don't think that this child should have his dad just pop up at a sporting event until there's been some reunification and we see how that process is working.
Well, we sure don't want to ambush Caleb. I think we wanted to do is maybe after that first, maybe Caleb, we can meet with Caleb in the first counseling session, maybe we can ask Caleb for that schedule.
Fair enough.
All right. The court will adopt the recommendation. We'll send one back then in February, and hopefully we'll have significant contact between dad and son between now and then. All right. The court will adopt the recommendation. And now, for the record, this matter is before the court and the plaintiff father's motion to modify parenting time. This hearing is being conducted via Zoom. The president is Attorney Christine Hills, representing the plaintiff petitioner Jesse Wallace. Mr. Wallace is present. In addition, defendant mother Katrina Linden is also present. Good morning, everyone.
Morning, Your Honor.
Parties have conferred this morning at length with Ms. LaPrade from the front of the court, who has provided the court with the following detailed recommendation. The recommendation is that anytime will be modified as follows. Father shall have parenting time on a 2-week rotating basis. Week 1, father will have parenting time Monday after school until Wednesday to school Wednesday morning, and Friday after school until Sunday at 7 p.m. On week 2, father will have parenting time on Tuesday after school until Thursday evening, 7 p.m. If there's no school, the parties will work together to agree upon an exchange time according to their work schedules. It's further recommended that both parties shall provide any demographic information in front of the court and other party within 21 days. Both parties shall have 2 non-consecutive weeks of parenting time with 30 days notice, presumably that's summertime. Perhaps we need to clarify that. Further, father shall provide health insurance for the minor children. Child support shall be abated as of November 30th, 2024. Mother shall claim both exemptions for both the children as exemptions for tax purposes. Extracurricular activities expenses shall be shared equally 50-50. To the extent possible, summer vacation parenting time shall be scheduled around cheer obligations for Melina. If both parties will notify the other of any third party living in the home. If there's an adult, the name and date of birth shall be provided in order for the other parent to do a background check on that third party. That is a recommendation. Ms. Hills, is this recommendation good with your client this morning?
Yes, Your Honor. With regard to the extracurricular provision, the sharing of expenses would be for agreed extracurricular activities. But yes, that other than that clarification, that is my understanding.
Okay, perhaps we should clarify that agreed upon extracurriculars will be shared 50-50. If they don't agree upon extracurricular, then it's up to the parties to agree. Is that correct?
Yes,
And then the 2 non-consecutive weeks, is that summer parenting time?
it is.
Ms. Pratt, good morning. If you could just put maybe in parentheses about 2 non-consecutive weeks, summer parenting time, just clarify that's parentheses, summertime, and then extracurriculars will be agreed upon extracurriculars will be shared 50-50. All right, with those clarifications, Ms. Linden, is this recommendation agreeable with you this morning?
Yes, Your Honor.
All right, Mr. Wallace, Ms. Linden, will you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you. Ms. Hills, if you can just confirm with your client his belief that this modified schedule is in the best interest of minor children, please.
Yes, Your Honor. Jesse, would you state your name for the record, please?
Jesse Aaron Wallace.
And you've heard the recommendations or agreement that has been placed on the record this morning, is that correct?
Yes.
And you and Katrina had largely worked through these issues prior to even getting here this morning, is that correct?
That's correct.
We tweaked some of the things and clarified some other things this morning.
Yes.
All right, and as written, as read by the judge this morning, do you believe that this agreement is in your children's best interest?
Yes.
And are you asking the court to adopt it as its order?
Yes.
Thank you. No further questions.
Thank you, Ms. Hills. Ms. Linden, will you please state your name for the record?
Katrina K. Linden.
And Ms. Linden, the agreement you've reached with the father of your children this morning, you've heard that. Do you understand the recommendation?
Yes.
Do you believe this, if the court adopts this, that this parenting time schedule will be in the best interest of your children?
Yes.
Do you have any questions for the court?
I do not.
Right. Ms. Hills, do you have any questions for Ms. Linden?
No, Your Honor. Thank you.
Obviously, pickups and drop-offs, the parties will work together. They already have an established arrangement. Is that correct?
It is.
Who's going to pick up and drop? All right. Very well. The court finds agreement between the best interests of minor children. The court will currently adopt that agreement. Copy mailed out to everyone. That will conclude this hearing. Thank you, Ms. Hills, for your assistance, and Ms. LaPrade. And the court applauds the two of you, parents, for reaching your own agreement. That benefits your children. So you can communicate and work together. And obviously, as you get older, things will change. So work together. Make sure that those extracurriculars are important for the children. So to the extent that one disagreement, try to work through that together. With that, that will conclude this matter. You can both zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
For the record, this matter is before the court and the plaintiff's motion for child support and child care expenses. This hearing is being conducted via Zoom. President Attorney Russell Smith, representing the plaintiff moving party, Paige Schluggle. Mr. Schluggle is present with Mr. Smith. In addition, Attorney Leslie's Carr is present, representing defendant Father Adrian Ringling, and Mr. Ringling is present. Good morning, everyone.
Good morning, Your Honor.
Court recalls there's already a child support order in place. The motion is to modify child support as well as provide for child care expenses. The parties have conferred this morning with Ms. Patrick, who has provided the court the following recommendation: that child support to be modified effective November 1st, 2024, the total amount of $1,375. Base support of $702, healthcare 115, ordinary medical of 22, child care of $534, for a total of $1,373. Uninsured medical expenses shall be shared as follows: the plaintiff mother paying 43%, defendant father paying 57%. It's based upon defendant father having 75 overnights. That is the recommendation. Mr. Smith, is this recommendation good with your client this morning?
It is, Your Honor.
Ms. Carr, is this recommendation good with your client this morning?
The only issue my client has is the start date, Your Honor. The child is currently not enrolled in daycare. So we're about halfway through the month of November, and they're asking for the full $534 payment for November on daycare, and she's not yet enrolled.
Will she be enrolled in 1st of December then?
She would be enrolled in December.
I think she's going to be enrolled very, very quickly, Judge. My client has been waiting to have the upfront money to enroll her. And it's my understanding that she'll be going in a matter of days. Is that correct, Paige?
Yeah, I plan to call the daycare after the hearing to finish the enrollment process.
Okay, what about, so the child's not been enrolled yet. How do we even know what the costs are?
I've gone to the daycare and I've talked with them already, and they've given me the price.
Okay. Well, perhaps that first month, get half of that to daycare can be paid directly. And then we can start this, adopt this recommendation effective December 1st. What about that, Mr. Smith and Ms. Carr? Can the parties communicate?
That would be fine.
I'm sorry, Your Honor. Are you indicating Mr. Ringling should pay the half of the 1/2 month directly to my client? Is that the correct suggestion?
Inquiring if that's reasonable, if the parties can communicate. Schluggle can provide confirmation the child's been enrolled in daycare and confirming the cost, and Mr. Ringling would reimburse her promptly directly one half of that, or the amount that's necessary to enroll the child the last 2 weeks of November.
I think that might work, Judge. Appreciate the suggestion.
Okay, so Mr. Schluggle, when you get the confirmation, just text or send something to Mr. Ringling in terms of the cost for this month, and the court will let Mr. Ringling provide the costs through the balance of this month. And Mr. Ringling will pay that directly to her. Talk about 2 weeks approximately. And then this recommendation is toward modified support, and including the daycare, will commence on December 1st.
That's acceptable.
So, Ms. Patrick, you just modified the date on that, and perhaps that sense that the defendant will directly pay any costs for daycare for November 2024, please. All right, Mr. Smith, with that, and Ms. Carr, do either of you want to board your respective clients?
Briefly, Judge.
Ms. Smith.
Ms. Schluggle, you've heard the agreement is placed on the record. Is this acceptable to you? You understand we could have had a hearing in front of Judge Braunlich, who may have ordered something very similar or very different.
Yeah.
By agreeing to this, you're waiving your right to have a full hearing. Is that acceptable?
Yes.
Have you been satisfied with my services on your behalf?
Yes.
I have no further questions, Judge.
Thank you. Ms. Carr, do you have any questions of Ms. Schluggle or Mr. Ringling?
Just briefly for Mr. Ringling. Mr. Ringling, you've heard the recommendation and that has been set forth today, correct?
Yes.
And with the modification of the start date and the direct payment of half the daycare for half this month to Ms. Schluggle, are you in agreement with that?
Yes.
Okay. Thank you. I have nothing further.
Mr. Smith, any question of Mr. Ringling?
Just one or two, Judge. Mr. Ringling, have you revealed all of your income to the friend of the court during this process?
Yes, I just have the money from the renters and my full-time job.
Very good. I have nothing further, Judge. Thank you, Mr. Ringling.
All right. All right, the court will adopt the revised recommendation effective December 1st. Mr. Ringling, please cooperate with Ms. Schluggle, get her that payment as soon as possible. to make sure your child's in daycare. Okay, with that, everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
You're welcome.
It's ready on the middle of 2, and she said you have 2 recs or orders.
Okay. For the record, this matter is before the court on the defendant father's objection to a referee recommended order denying his motion to modify custody. In addition to the plaintiff's motion for order to show cause. The hearing is being conducted via Zoom. Are you Ashley Andrews?
Yes, Your Honor, I am.
Ms. Andrews, one suggestion, your show cause is 8 pages. You need to be precise. Court has limited time. What the court suggests is you modify that so I can read it. You have 8 pages of just goes on and on and on and on. It's a hard time following what your allegation is.
Your
Any
Honor,
have you texted Kenneth this morning, reminding me he's got court?
no, Your Honor, he's an adult and that's not my responsibility. I'm not his mother.
I understand, but this court is a busy docket. I mean, maybe you maybe forgot about it and he'll appear and we can take care of it today rather than you have to take additional time to come back in a week or so.
This is on the defendant's objection. I'm not sure why he's not present.
All right. Okay, so you have no objection. We'll also address your show cause then. I mean, the court would like to deal with things. Can you please text him? Do you have a phone number for him?
Sure, I can text him right now through the app close appointed application that we have.
Any on him. Rather than kicking this can down the street, let's get him here today so to resolve all these matters.
Message has been sent via app close, Your Honor.
Thank you. We'll give him a minute to see whether he responds. If you can let the court know if he responds at all. Any response, Ms. Andrews?
No, he has not seen it since 7:37 p.m. yesterday evening when he didn't respond to my question about our children then.
I'm sorry, you texted him last evening and he did not respond to that as well?
That is correct.
Okay. All right, well, Mr. Andrews was given the date and time today for his objection to the referee recommended order. It was scheduled for 10:30 this morning, November 13th. Mr. Andrews has not appeared. He's not contacted the court by phone or otherwise. Accordingly, the court will enter order confirming and adopting the referee recommended order that his motion to modify custody be denied. The other provision of that order, of course, will continue. Ms. Andrews, neither of you shall discuss custody or parenting time issues with the minor children or in front of them. And neither of you should make any disparaging remarks about the other parent in front of the children. So that is adopted on account of Mr. Andrews' failure to appear.
Your Honor, I'd like to state on the record that that has been adopted several times throughout our case during the matter as well.
And with respect to your motion for to show cause, Ms. Andrews, you need to serve Mr. Andrews with that. I don't see a proof of service in the court file.
Your Honor, there is a proof of service signed by Emma Young in the county clerk. She mailed it on the 7th of November.
Oh, thank you. The court does see that. Ms. Young did mail those to. Do we have does the front of the court have that same address for Mr. Andrews?
I can check, Your Honor. That is the correct address.
All right. All right. So Mr. Andrews failed to appear in that matter. So the court will adjourn this matter to November 26th at 10:30 a.m. Let's see whether or not he appears at that time. That would be a Zoom. Any questions, Ms. Andrews?
Not at this time.
Okay, I'm not sure what it's going to take for you and Mr. Andrews to raise these these children you brought into this world. 3 children, but obviously things are not good. Ms. Brower, I guess we'll wait till then. The courts, when come back Tuesday, the court's probably inclined to have the children interviewed. And the court's reluctant to put the children in the middle, but after the 2 of you have done that, telling the court that's what we need to do is have the children interviewed by the front of the court so we get the true story of what's going on.
Your Honor, in my motion, I talk about the well-being of the children, addressing that specifically and being interviewed by the court as the exchange is week on, week off, and it's already tough enough for them to adjust to the different environments. The children are all in therapy, and when they are with me, they are attending their weekly sessions. We do have family counseling sessions when the boys are with me. However, when the boys are not with me, I cannot speak for that. I do know that there have been several instances with our middle child in relation to his academic behavior and insubordination in school, and to be honest, parental alienation from that child right now at this time. So putting the children in that, I would request that the friend of the court, if they're going to interview the children, that they reach out to the therapist directly as they've developed a relationship with the children.
Right, the counselor cannot talk with third parties, so you need to sign a release authorizing those counselors to talk with the front of the court.
I'm happy to do so.
So there was a recent parent-teacher conferences for the children?
Their parent-teacher conferences for first marking period has thus passed. 2 of the boys, the oldest and the youngest, are doing well in school. Our middle child is not doing good in school. Actually, the school sent out an academic notice to evaluate his well-being within academics in school. That was sent out October, I can tell you the date, October 22nd. And they're looking at special education resources. His academics for first marking period, he had a 1.55 GPA. He is failing in several classes and has been, and he still continues to show that at this time. I presented facts and options for him to attend homework help as we did in the past. Per the school, he has only attended 1 day, which is the day that I sent him to homework help. Clearly, the child has some emotional concerns, and that's coming from the school staff, administration. That's also coming from his therapist, and the child is completely alienated from me at this time.
Is Mr. Andrews aware of all this?
He is very aware of all of this. Just a week ago, Garrett came to my home after we went to the wrestling parent meeting, and he wasn't in my care for more than an hour before he extremely lashed out and was extremely vulgar, and with the other 2 children in the environment, and Nana was in the environment as well. From there, he left and went to Dad's second place of employment, which is across the street from my apartment complex. And the child Garrett was sending very explicit messages to myself and to my mother. The child is out of control at this point. Just yesterday, his therapist sent me an email about his behavior as well.
And you've discussed all this with the counselor, the child's counselor, correct?
That is correct, yes.
All right, we'll address all these issues and come back November 26th at 10:30. Hopefully, Mr. Andrews will appear at that time. Obviously, to the extent you have any contact with them, encourage them to appear so that the 2 of you as parents can provide input.
I would agree, Your Honor.
Okay, all right. We'll mail out notes to both of you that your show cause adjourned to November 26th at 10:30. All right, thank you, Ms. Brower. You can, that will conclude this matter, Ms. Sanders. You can zoom out.
Thank you. Have a good day.
Thank you. Good morning. It appears that Kenneth has not appeared this morning. He did not appear on November 26th. A copy of the November 13th order was mailed to him, setting forth the review date today at 10:30 via Zoom. The record is now about 10:53 a.m. Mr. Andrews has not appeared. He's not contacted the court. Is Mr. Andrews exercising any parenting time?
He has the children currently right now. He did show up yesterday evening for Colin's team meet. The day after court on November 14th, so we had court on November 13th. He did not show then. Never received any response from the message you had requested me to send. November 14th, he took a half a day off of work and took the kids out of school for a half a day for a dentist appointment that was 5 months since their last appointment, so not necessarily required. So they missed school and he missed work. I'm not sure why he's not here. He's received proper notice.
Have you tried texting him?
I can do that this morning if you'd like me to, but I have not.
When you saw him yesterday, did you remind him that you had a court hearing this morning?
We don't communicate in person. I have a PPO that's in place against him. He violated that in May and they extended that and everything is covered now on the PPO, including additional addresses. So we don't talk in person or communicate. The communication via AppClose is actually very harassing, which is one of the things that's in my show cause motion for communication.
The court received a recommendation this morning that your motion for show cause is withdrawn.
Yep.
That you've been noted that you can refile if you want in Genesee County. Because this court cannot transfer this case if there's anything pending.
I understand.
So you need to know you're withdrawing your motion. And it's also noted that your petition to change venue, transfer this case to Genesee County, be granted. That was filed on July 15th. Yeah. You and your children live in Genesee County, is that correct?
That is correct.
Mr. Andrews also lives in Genesee County?
Yes, he does.
Right.
The children attend school in Genesee County. The PPO is active in Genesee County. He works in Genesee County.
All right, it appears since there's nothing pending now, you've withdrawn your motion for a show cause. The court will in fact enter an order transferring venue of this case to Genesee County. All right, that will conclude this matter. You'll receive a copy of that order. And so any further future motions you need to file with Genesee County. Also, you'll need to pay a filing fee to Genesee County. I don't know how much that is, but they will notify you. You need to pay a filing fee up there.
Okay.
All right, that concludes. You can zoom out.
Thank you. Have a good day.
Welcome. For the record, this matter is before the court on the plaintiff's objection to a referee recommend order that the defendant fathers parenting time of 1 week during Christmas break and 2 weeks during the summers. In the event this hearing is being conducted via Zoom, President Attorney Leslie Carr representing the plaintiff, objecting party Jennifer Rice. Ms. Rice is present, and defendant father Jose Adrian is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
The court has, the parties have conferred with the front of the court. The court's received the fine recommendation from, I believe, Ms. LaPrade. That seems to cover a lot of the issues. It's recommended that that referee recommend order be adopted but modified, namely the plaintiff has the defendant's permission to move the adopted minor child out of state Michigan. To what state, Ms. Carr?
Your Honor, my client is looking at locations in Georgia and in Florida at this time. Mr. Adrian is aware of that and gave his permission to, basically was open-ended and said wherever she needs to move with the child and it's in the child's best interest, he would agree on.
Is that correct, Mr. Adrian?
That is correct, Your Honor.
So if she moves to Montana, California, that's all agreeable?
Yes, if that's what we need. Like when she comes, I just pay for airline tickets to fly her here when she wants to visit. So as long as they got an airport near.
Okay, so it's okay if she moves to California or the state of Washington, correct?
Yes, Your Honor, yes.
All right. So it's noted for the record that the defendant has no objection to whatever state the plaintiff mother and the minor child move. Obviously, Ms. Rice, important that you keep Mr. Adrian informed of that address once you make that
Always.
change. Is this change going to occur at the end of the school year?
Probably spring break time next year.
Well, why this child?
Within 3 months.
No, the court has a problem with that. It's a 12-year-old child. We're not going to yank him out of school.
We have spoke about it, her and I would make sure it was within the right times. I'm very transparent.
This court has a problem. We don't, the court does not believe it's best for a child to yank a child out of school, a 12-year-old. This is not a 6-year-old in first grade. Why can't you wait till the end of the school year, Ms. Rice?
Because of job opportunities. I have a job opportunity lined up.
Well, why don't you come back? Once you get that job opportunity, you can present that to the court.
It can wait to the end of the school year. That is fine.
All right. That's what the court prefer.
Okay.
And if in fact that job can't wait, you can petition the court. But Mr. Pratt, if we can modify his recommendation, the plaintiff can move the minor child out of state of Michigan at the conclusion of the current school year. It's also noted that the parties shall share equally in extracurricular activities as the parties can agree. The minor child is currently involved in softball and basketball. Particularly with this child being actively involved in school sports, the child should be able to finish. We're almost halfway through the school year. The child should finish the school year. The issue of child sports referred to the front of the court for formal investigation recommendation, with each party having 21 days in which to object. And finally, a scheduled hearing before referee McKee on November 18th, 2024 is vacated. That's the recommendation. With one modification, Ms. Carr, that the child or domicile shall not change till the end of the school year. Is your client otherwise agreeable to the recommendation?
Yes, Your Honor.
Mr. Adrian, do you understand the recommendation, what the court has stated?
Yes, Your Honor.
All right, so the court will adopt the recommendation with the clarification and modification that the plaintiff, Ms. Rice, shall not change domicile of the minor child until the your daughter has completed the current academic year. So that will be in late May or early June of 2025. And if in fact, Ms. Rice, you have a job opportunity that presents itself and they will not wait on that, then you can petition the court. We can always consider a change at that time.
Yes, Your Honor.
Right. Mr. Adrian, do you have any questions for the court?
I do not, Your Honor.
Right, Ms. Carr, do you have any questions for either party?
No, thank you, Your Honor.
Again, if this child was first grade, second grade, maybe not a problem, but this child is 12 years old and involved in extracurriculars, the child should finish the current academic year. Particularly since plaintiff mother has no specific job offer opportunity to present at this time. All right, so the court will adopt the recommendation as modified. Thank you, Mr. Brad. Now we'll conclude this hearing. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
And that
Thank you.
updated recommendation is in your queue.
Calling the matter of Aaron Dewey versus Sarah Dewey.
For the record, this matter is before the court on the plaintiff's motion to suspend defendant's parenting time. This hearing is being conducted via Zoom. Present is Attorney Chris French, representing the plaintiff moving party. Aaron, is it pronounced Dunn or Dunny?
Dunn, Your Honor.
Dunn. All right. Good afternoon, Mr. Dunn. In addition, Attorney Catherine Sikorsky is present, representing the defendant Sarah Dunn, and Ms. Dunn is present. Good afternoon, everyone.
Afternoon, Your Honor.
Good afternoon.
The court previously denied the plaintiff's request to suspend parenting time, but I did schedule the matter for hearing today, expedited hearing. The parties have conferred with Ms. Patrick. Who's provided the court the following recommendation. The parenting time continue as previously ordered. The ex parte did not grant you relief, Ms. Patrick. You can delete that. It's unless I'm missing something.
Your Honor, it was just the third statement that says the order was going to enter. I'm just trying to clean up the record, but I can take that statement out if you want.
Expedited order of October 24th. That was simply, all I did was set it for hearing today, so the court did not modify parenting time or custody.
Okay. Did you want me to remove that statement?
Yes, please. Creates confusion. Issue of defense parenting time motion set for November 19th at 10:30. Why are we kicking this down the street?
Because there's a motion that has been set for child support, and then this is the defendant's parenting time motion. Mr. French has not been retained by his client regarding the motion.
Come on, I'm gonna want the parties to discuss it this afternoon. The court's not gonna keep coming back every week. We have all parties here, 2 attorneys here. We're gonna address child support and any other issue that's outstanding right now. We're gonna address this afternoon. So put you back in the breakout room.
Your Honor, I don't have any of the information needed to represent my client at this time. I haven't been involved with that motion at all. I filed the ex parte motion. Now, my client intends to hire me, but I'm not in a position. I don't know the case. I don't know the specifics. I don't know the history. I'm not in a position to be able to assist my client at this time.
Well, Mr. French, you attached your motion, copy of the judgment of divorce. You don't know the history of the case?
Well, I don't know the recent history. Well, I've not even seen the motion that Ms. Sikorsky filed. They had a mediation with Josh and they came to some agreements. I don't know what those agreements are. I'm completely out of the loop on that, Your Honor. I'm not.
Mr. French, after our last phone conversation, I did send you a copy of the motion on October 30th.
I understand that, but I was not retained on it, so I've not even opened that email yet.
Okay, I see in the file there's a motion to clarify terms of judgment set for November 19th at 10:30. Is that in this court's docket?
That's the motion. We filed to clarify the judgment. We were able to resolve some of the issues at mediation, but not the issue to clarify parenting time that we had set.
It is set on your docket, Your Honor.
All right. Okay, I guess we'll address it parenting time, and that is the only issue then, correct? It's parenting time?
I believe that Mr. Dunn had filed for child support modification.
That's scheduled in front of the referee, Your Honor, because he filed it in pro per.
Okay, that's before referee McKee on November 19th at 10 o'clock.
That's
So
correct.
will both matters be before this court, Ms. Patrick? Are we going to vacate the referee hearing?
That's up to the court, Your Honor. I was going to leave the child support in front of the referee, but if this court would like to take that issue and vacate the referee order, we can do that.
Probably makes sense. All right, so the parenting time the court will enter the recommendation. Parenting time remains as previously ordered. Issue of parenting time as well as child support shall be addressed by this court November 19th.
I will vacate it, Your Honor.
10:30, and we'll vacate the referee hearing before referee McKee, I believe at 10 o'clock that morning.
Correct.
Mr. French?
Yes, Your Honor.
All right, Ms. Gorski, anything further?
No, Your Honor.
All right, this matter's over till we'll see you then in a week.
Thank you.
Thank you, Your Honor.
Okay, this matter, you can zoom out. Thank you, Ms. Patrick. Mr. Brock present in your office, Mr. French, or is he present on audio?
He's coming in right now, I believe, Your Honor.
He's here. There he is. He's here.
All right, Mr. Brock is present. Can you hear the court, Mr. Brock?
Yep.
All right. In addition, Attorney Alex Goldman is present representing the defendant, Jamie Brock, and Ms. Brock is present. The parties have conferred this afternoon with Ms. Brower, who's provided the court with a fine recommendation. And actually, our last court hearing of October 17th, Mr. French, you were to prepare an order, and I don't see an order in the court file.
My client did not agree with the parenting time schedule. He did not sign it, and brother counsel had the order, and I thought he was going to go ahead and file it. I did sign that order, Your Honor, with brother counsel. So there was a question on the order as well, and maybe your notes could clarify the parenting time schedule for the Tuesday, Wednesdays. We were under the impression that the Tuesday, Wednesday parenting time was every other week, and then mom would get every other weekend. And I'm not clear on it, Your Honor. Brother counsel said he has listened to the tape and it's supposed to be every Tuesday, Wednesday. My client doesn't agree with that part of it. He thought it was every other Tuesday, Wednesday.
Well, there's too many files for the court to take personal notes in each file, and the court has not reviewed the transcript. In any event, the parties have conferred this afternoon with Ms. Brower from the front of the court. Is provided the court's finding address that mother's parenting time should be every Tuesday from school to school Thursday morning, and every other weekend, Friday from school to Sunday at 7 p.m. Mother shall be responsible for transportation to and from school on her time. Father shall transport on Sundays. Father shall stay in his car during Sunday exchanges. Further, the minor children shall be enrolled in counseling. There should be no discussion of this case with the minor children or in their presence, and there should be no disparaging remarks made by either parent against the other. That is the recommendation.
Right.
French, is this recommendation agreed with your client this afternoon?
No, he does not want the every Tuesday, Thursday. That's the big problem with this because the kids are in school and he's having a difficult time getting them over there. As tumultuous as everything is, he thinks it's going to be problematic if they go during the week at all because the older kids are really bucking him on it. And I understand.
Well, of course, they're minors, so it's they're not driving the bus, Mr. Brock. When you and Ms. Brock cannot agree, this court's going to drive the bus. So the children need to have a relationship with their mother, and you need to facilitate that.
Your Honor, if I may respond quickly, he's telling me that the daughter is talking about running away already if this is forced upon her, and he just didn't want to run into those problems. He's been a little bit more stable in the relationship for the children for the last year and a half, and he's concerned that he would start running into those problems as well. So he's going to do what the court orders him to do as best he can, Your Honor, but I think we're going to have problems with this parenting time schedule.
Why is the daughter not involved in counseling if she's making such allegations and threats?
I was made aware of that this morning, and we've agreed to counseling with Ms. Brower this morning, so we're going to try to get all the kids counseling as well. And I think mom and dad probably should be involved in that at some point, and maybe the parenting time class as well. I think brother counsel would agree with what I've recommended on the counseling at least, you know.
Mr. French, court understands maybe you not be aware, but if dad was aware of this, he should have scheduled counseling when the kids were making those kinds of comments.
I believe she was
in counseling, need a professional assistance.
Your Honor, she was in counseling, and then sports and things started, and cheerleading, and she said she told her dad she feels pretty good, but they had talked about it, and then she stopped the counseling when sports activities took more of her mind time, her mental time. So he did have her in counseling, Your Honor, at one point as well.
Well, the court's going to order that counseling immediately commence, Mr. Brock. It's got to work around her sports. Obviously, when she's threatening to run away because she has contact with her mother, there's some issues that need to be explored with a professional counselor.
I didn't mean run away. I meant walk away from the car. She's not going to force herself to get in. That's what I want to clarify that. Not run away. She's just going to.
All right.
Sorry.
You got to talk to her and get her involved in counseling. Mr. Goldman, is this a recommendation good with your client?
Yes, except we just want to add one extra provision that the children shall be sent with enough extra clothes for mother's parenting time. Right now, all the clothes are at dad's home. All
right. Any problem with that, Mr. Brock?
I'll give what I can. Yeah.
Not acceptable, Mr. Brock.
I have what I have. She took all the dressers with clothes in it. I don't know how she doesn't have clothes.
Neither of you know where the children's clothes are?
Your Honor,
when we moved out, sorry if I'm cutting anybody off. When we moved out, I got garbage bags full of clothes. She took all the kids' dressers because I said, take all the kids' bedroom outfits because she's moving. And I have other stuff in storage. And I have what I have here. And the last time I heard that, I thought all the clothes were in the dressers. She did not tell me that there's no clothes in here. So the kids pack their bags when they go. And I pack Carson's bag. And I just had to go out and buy clothes for my kids because they grew up and got bigger. She's got money coming in. I don't understand why she can't go out and buy clothes.
Officers, clear breakdown communication. Is there any of the children's clothing in storage, Mr. Brock?
No, I mean, just older stuff for Carson to grow into that are hand-me-downs, but he's not into that. But other than that, no, his dressers are what I have here for a week and I wash it. I don't have a large amount of clothes. I thought the dressers were full that she had.
Well, do your best. Has discovery been concluded on this case, Mr. French and Mr. Coleman? Do we need a trial date?
I'll defer to Ron.
I'm sorry, Your Honor, that was the court, one of your courtrooms calling me on an arraignment. I'm sorry, you asked if discovery was over?
Yes, these parties need to get divorced. And obviously, Mr. Brock needs to realize a 19-year marriage. Is that correct? I mean, he's got to be aware of the pitfalls of spousal support if he cannot reach an agreement, but you've already mediated, I believe, twice with no success. Things seem to be word. These parties need to get divorced. So the question is, has the discovery been completed? Do we need to schedule a trial date today?
I think a trial date would be in order, Your Honor. We can always cancel that. Brother counsel and I work pretty good together on dates and that kind of thing. If he agrees with that, Your Honor.
Well, have you exhausted all efforts to have the four of you talked? You've tried with Mr. Walker twice, unsuccessful. I don't want to schedule a trial date if in fact there's some prospect of settlement.
Your Honor, if I may.
Go ahead, Mr. Goldman.
I agree that brother counsel and I do communicate very effectively. The custody and parenting time issues have been incredibly heated. My hope is that with guidance from the court right now on a temporary basis, it will allow things to cool down and all the property issues are resolvable. The problem, as I see it, is that the emotions of the custody and parenting time have gotten in the way of any kind of global resolution. So my request would be to not rush a trial date at this time. If we could set it for another pre-trial and allow Mr. French and I to advise our clients accordingly.
I would agree with that, Your Honor.
So you're suggesting custody and parenting time are the only outstanding issues?
No, but the property issue, we just haven't had a chance to talk about property because there's been a lot of fires to put out.
Right. Personal property, I think, has already been divvied up. We do have some issues with leased vehicle that she was supposed to pay my client some money back on over mileage. That is in the status quo order. And she's arguing that she doesn't owe that money back, only half of it now. And there's some damage to the car that my client's going to have to pay for because the lease is in his name. So that's still an outstanding issue. So.
There's also a camper and a boat.
Jamie. So, Your Honor, there are property issues. My personal feeling is that the property issues are solvable if we can get to a stable parenting time arrangement.
Yeah, I agree with brother counsel, Your Honor. Maybe another pretrial date. See how this parenting time thing is going, and then go from there.
Do we need to refer the issue of custody parenting time to the front of the court for formal investigation? I hate to put the children in the middle. Being interviewed by the front of the court.
My client would like that, Your Honor. He'd like for someone to talk to the children because they think that dad is the one that's not allowing parenting time when it doesn't happen. And the kids are very headstrong and they're upset about things. And I think someone needs to talk to them away from mom and dad.
And Your Honor, we feel the opposite. We just don't want to put the kids in the middle of this. So we would object to front of the court.
Parents need to, they brought these children into the world. They need to agree. Otherwise, if they cannot, that's what's going to happen. The children will be in the middle. They don't want to be interviewed by the courts. But if that's what the parents, if they cannot agree themselves as parents, shame on them. They're going to have the court raising their children. It's very unfortunate. All right, so we'll add in this recommendation, another pre-trial conference. What are you suggesting, 30 days?
That sounds good.
Maybe 45, but sure.
You want to do before Christmas or after?
My preference would be after.
Yeah, that's.
Well, do we need to address holiday parenting time?
So part of the prior order was for the front of the court holiday schedule.
Well, has it been reduced to writing? I know we've had agreements. Is there a written order that provides for holiday parenting time?
No. Not that I've seen, Your Honor.
Okay.
So, well,
Right. The court's
Again,
can order parenting time shall be per the front of the court holiday schedule, unless the parties agree otherwise. So we're not going to spend time piddling back and forth on that. If the parties cannot agree, it'll be according to the standard front of the court holiday schedule.
Okay.
They can both get a counsel. You can provide your clients with a copy of that. And so everyone will be in town the last week of December. Is that correct? Do a pre-trial on what, the 31st or the 24th of December?
I am unavailable on the 31st and the 1st, also on the 24th and the 25th.
Right, well, we're going to, how about 17th or 18th?
Are we talking January?
I can do the
Mr. Bowman suggested late December.
December 18th is the only date that works of those you listed.
I'm sorry, Mr. Bowman, can you repeat that?
December 18th is the only date that works for me.
And that's fine for me, Your Honor.
Okay, do we have a second on December 18th? That's it, Andrea. Do we have December 18th? Let's see. What's available on December 18th?
I'm full in the morning.
Okay, what time is available in the day, during the day?
We can do 9:15.
We can do afternoon too.
Okay, you want to do 1:30?
How about December 18th at 1:30?
That's fine, Your Honor.
Good for me, Your Honor.
All right. All right, Ms. Barr, if you can add that the party shall appear for review December 18th, 2024, 1:30 p.m. via Zoom. Review things. So other than allowing things to settle down in terms of the emotions regarding custody and parenting time, is a further discovery necessary with respect to retirement plans, income?
I don't think all discovery is necessary. I think Mr. French and I, if there's additional information we require, we've been quite good about exchanging that.
Right.
Okay. All right, the courts will require the request that the parties please can move forward with discovery so we can make some definitive decisions on December 18th at 1:30. In the interim, the court's going to adopt the recommendation this afternoon of Ms. Brower that mother's parenting time should be every Tuesday after school and then take them back to school Thursday morning. Dad, please encourage the children to give it a try. And it's important they spend time with their mom. And Ms. Brock, you need to be sensitive to their needs. The children are getting older now, and yes, they will. They can. The court will certainly listen to their voices, but at this point in time, the court wants to make every effort to see if this works. Mom is responsible for transportation to and from school, and then weekends. There'll be mom will pick up Friday after school. Dad will pick up Sundays at 7. Dad will stay in his car. The children will be sent out to the curb for Dad to pick up. Who's going to initiate reaching out to a counselor for the children? Will you do that, Mr. Brock?
I'm sorry, what was that?
Will you be the one reaching out to contact a counselor for the children?
Yep.
Okay. All right. Right. Court will adopt it again. Once again, the recommendation we're going to add to it that the party shall appear before the court for review of parenting time. Whatever issues need to be reviewed, we'll review those on December 18th to 2024 at 1:30 p.m. via Zoom.
Your Honor, are we going to go get a recommendation and interview the children?
And not at this time. We're gonna see what happens between now and then. And
Okay.
if necessary, we can address that at that time, Mr. French.
Okay.
All right, that will conclude this matter. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you, Judge.